Let's start with you, Mr. Abioye. What has informed this particular strike of Houston at this time? The fight for autonomy, financial autonomy more specifically, by the judiciary has been on for a while. But what triggered it this time around?
Well, that question has been asked severally. Don't forget that sometimes in 2015, we were on strike for the same purpose.
Indeed.
And we suspended it based on the fact that people intervened, major stakeholders intervened, that we should still wait for the governors, the accountant general of the federation, and whoever is concerned for the implementation to do the needful. So we were taking our time to look at the situation. And then, when we saw that nothing is coming forth, nothing seriously was coming forth, we have to take the bull by the horn again by resuming the strike that we suspended sometime in 2015. So nothing new triggered anything than for the fact that, remember there was a law that was signed by the president, that's the other 10, which ought to have aided the implementation of that financial autonomy. But to our amazement, the foot dragging on it, there was implementation committee that was set up by the federal government, and that was the purpose for which we held on, and we did not do anything. But when we saw that nothing was coming forth from the end of the implementation committee as well, we have to resume the strike. That's just it, on the same matter.
Well, it's sad to see that, even though you were appealed to and you shelved your strike, nothing happened. But some people will say that it's nothing new. Many strikes have been shelved, and we see them resuming, especially after nothing has happened. We had that situation with doctors, resident doctors, saying the same thing happened. ASUP, a number of, unions have also said that as well. But so far, so good. It would seem that your action has now yielded fruit. We've seen governors hold meetings and finally say, look, we would implement by May. That's when they're hoping to start implementation. In some states, they say they have actually started the implementation. Some states have complied, maybe not fully, like Lagos State. We also saw on the news yesterday, members of the MB acknowledging that at least they have been able to comply substantially, not fully. Does that give you any comfort that, some states seem to be showing how it can be done?
Not yet, Uhuru. Yet, definitely. We are not. We appreciate the fact that some states have taken steps to implement the financial autonomy, but like you said, partial compliance is more or less like no compliance. The rule of law, there's nothing like I'm trying to obey or I'm trying to obey partially. What we need to put at the public domain is that this financial autonomy we are talking about, they are in two parts. We have, for instance, we have consolidated fund, federation consolidated fund that has to do with federal government fund. And we have also the state consolidated fund. So that has to do with the IGRO at the state level. So the IGR at the state level is perhaps what some states are saying they are complying with in terms of implementation of the autonomy for the judiciary at the state level. So the fact still remains that except and until we do the needful at the federation account, the implementation of the autonomy at the federation account, it's more or less like we have not done what's supposed to be done in full, definitely. So we are not yet happy with the situation because, for instance, like I said, allocation that come from the federal government, every month, a part ought to have gone to the judiciary by the law, the provision of the law. That's section 81, subsection 3, section 162, subsection 9. The fund that come from the federal government every month, a part of it ought to have gone to the judiciary through the NJC that will transmit the same down to the rest of courts according to the law. So the one that being implemented partially is the one of section 121, subsection 3, which is at IGR at the state level, upon which the budgets are based at the state level. So we are not yet happy with the situation of things. Yeah, definitely.
Okay. We will come to, I'll come to you, Mr. Okutekpa, shortly as to the role of the MBA and the order given by the MBA that its members must keep visiting state executives until this implementation is achieved. But let's quickly see a clip of what happened, what transpired yesterday at the meeting that Justin was supposed to hold with the Minister of Labour.
The Governors Forum on one side, the judges who are heads of courts, the Judicial Union, the Parliamentary Union, and the speakers, Conference of Speakers. So they have reached some agreement at the parley they had with the Chief of Staff. And that was why we reconvened for today. We gave them an appointment for today. We gave them another appointment by last Friday because we were in the know that by yesterday, the necessary agreements will have been reached. And once necessary agreements have been reached as memorandum of understanding, we bring it, everybody here, and detail them with timelines and time frame. So as they have finished them and come for this meeting. But there were some loose ends they did not tie up. So we took permission. I asked the permanent secretary and the officials responsible to explain to them, to the two unions, that they have to exercise patience, to enable us tidy these areas before meeting with them. So nobody slighted them, nobody refused to meet with them. We wanted to meet with them so that the meeting will be fruitful, so that whatever is signed here will be implementable. So that is, in a nutshell, what happened today. And we are making contact with them by tomorrow. And this work have not even finished. The government side have to go back. The Solicitor General and Implementation Committee, Secretary NJC, and all of them, they have to go back and tie up the loose ends that I have pointed out to them here.
Well, that's the Minister of Labour. That's explaining his own side as to why he didn't show up for the meeting he was supposed to hold with your union yesterday. Did you find his explanation satisfactory?
Not at all. Because in the first instance, the meeting was scheduled for 3 o'clock. We thought perhaps if at all there's going to be any change of time or date of the meeting, we ought to have been communicated too. Because when that meeting, some of us earlier, and 3 o'clock until 4:30, we thought maybe perhaps they're not ready for that meeting. And don't forget this fasting period for some of us. So they need to go and take care of themselves. So nobody appealed to us initially to say that, okay, the honorable minister is doing something or is attending to some other things for us to hold on. Obviously, it would have been reasonable. So, but nobody came to us to explain anything until when we stood up. And we were on our way at the staircase when, the permanent, like you said, the permanent secretary came over to tell us that, so it was something that ought to have been done earlier, was that we were at the conference room. So that's why it's not satisfactory to us, although we have heard what he said. Mm-hmm.
Would you be going back if he reaches out to your union today?
Our doors are open. We are ready to, if truly and sincerely, something will be done that will be meaningful. We're not happy going on strike. We are Nigerians, and we don't have any other country going. So we want the economy to work. That's the purpose for which we went on strike in the first instance. So if we are being called for a meeting, why not? We're obliged, definitely.
Mr. Kutekwe, let me come to you. It would seem that somehow the lawyers fight for the rights of everybody else but have left out the rights of the judiciary itself in asking for what it's due it, which is financial autonomy. Why has it taken this long for us to wake up?
Marco, I can't agree less with you. You are completely right. And I think that, speaking for myself, what Jusun is doing ought to be the role that we should play as professional association. Mark you, judges cannot speak. They are to be seen sitting and they cannot talk. So that is why, for instance, we have a body called Nigerian Bar Association, whose motto is promoting the rule of law. So I'm not speaking for Nigerian Bar Association. I'm speaking as a member of that association that believe reasonably too within me that we ought to take the lead, not to play the second fiddle role. Because whether in private practice, whether in business, whether whatever vocation you chose to do after being called to bar, you are a member of that noble profession, the profession that people look onto for succor, for comfort. Indeed, we are the only profession that has one arm of government exclusively devoted to it with a defined qualification. So for me, I think our role, we need to be more, we need to bite more than backing. We have issued too much press conferences, press releases. We have appealed too much. And lawyers are supposed to be the social engineers who give directions how things are to be done. So come back to the real issues at stake is this question of financial autonomy. And like I said in the press statement I issued yesterday, I commend Jusun for taking this bold step. It's the right thing to do. It has to be done. It must be done. It shouldn't be left undone. Because the hope of the common man to get justice in Nigeria has gone into serious jurisprudential dehydration. And the courts are just glorifying, I don't know how to call it, not even a correct primary school. Most of the times you see our judicial officers sitting on bench and with no air conditioning, with no correct court hall. And so the Constitution, the framer of our Constitution, says that money that is meant for the judiciary in any financial year should be released to the heads of courts. Now, arguments have been canvassed by erudite legal practitioners of note as to whether who has the responsibility or not. I don't want to go into that semantic. But all that I can say here this morning is that there is an admission on the part of the people that are responsible to obey Nigerian Constitution that they are violating Nigerian Constitution on a daily basis. For me, if we have independent legislature, these are impeachable offenses because every governor in Nigeria subscribed to oath of office and oath of allegiance to obey, defend, and protect Nigerian Constitution. Section 81, subsection 3, Section 169, subsection 3, Section 121, subsection 3 of Nigerian Constitution are parts of Nigerian Constitution that the governor, the president, and even the ministers and the commissioners, local government chairmen, all subscribe, even the judicial officers, subscribe to defend and protect. And so it does not require Jusun to go on strike for you to pay fidelity and obedience to the provision of this Constitution. But Maokwa, do you know why it is being done? What? Nigeria is the only country I know in this world that will respect no rule of law. The rule of convenience is what we operate in Nigeria, not rule of law. Because where there is rule of law, due process, it does not require horsewhip for any governor to direct, to release, and give to the heads of court the monument for the head of courts. But I won't say that. Like I also say in my write-up, giving judicial, financial autonomy to judiciary is a tip of the iceberg than the kind of independence of judiciary that I, as a legal practitioner, will require that Nigerian judiciary should have. For instance, our recruitment process to the bench is faulty. Indeed, in this country of today, what you know does not matter, is who you know that matters. And so the third arm of government, which is the judiciary, which has a defined qualification, it is not sufficient for you to say, I'm a legal practitioner called to Nigerian Bar and have been a lawyer for 10 years, 12 years, 15 years, therefore I should go to the Supreme Court. No. We need the best of the best to man the judiciary. When you have a lily-livered judicial officers that have been imposed on you by the power that be, or a lily-livered judicial officers that does not know his left from his right, then when you appear before that judge, you are in serious punishment. One, punishment of understanding the jurisprudential basis of your argument. Two, punishment of understanding even his left from the right. So when you have such people manning the bench, then justice is not only denied, it is murdered. So we must look at our recruitment process. Two, you don't just get anybody to the bench who has no strength of character. You require strength of character to work in the kingdom of Nigeria that is infested with what I refer to as a cancer called corruption. Because where a judicial officer is being paid a peanut and is adjudicating over a matter worth trillions of naira or dollars or pounds sterling, and all you need to do to get that judicial officers to give you judgment devoid of justice is to offer to that judicial officer money that is fantastic money. And if he doesn't have a strength of character, the kind that permit me the use of this ecclesiastical example, the kind of character of Joseph, who has to run away from Potiphar's wife because the wife does not belong to him. So we don't, until we have a judicial officer with strength of character who does not support appearance of impropriety and who defend the oath of office as giving justice to all manner of persons, irrespective of tribe, religion, political affiliation, then we have not gotten an independent judiciary. So the character of a judicial officer, it matters a lot. Now, before now, nobody lobbied to be made judges. And so we need to give merit the opportunity. Not who you know, but what you know. The other point I will need to make is that, yes, this strike must be fought and must be fought with an evangelical commitment. But in fighting, when the financial independence is won, how are we then sure, what have we put in place that we are not going to run into the murky water of the kind of thing that the local government in Nigeria suffer in the hands of state governments, where what is due for Maokwe is being held by Okutepa and not given to Maokwe to function well. So how are we going to be sure that when money are released to the heads of courts, the heads of courts will not behave like emperors and not allowing the money to trickle down to the people that need it to work? How are we sure when contracts are to be awarded, the cancer operating in our system called corruption will not invade that third arm of government? In the award of contract, in the award of execution, there will be no kickback. We must put that in place and monitor it and implement it so that we don't run from fry pan to fire.
Which is a very big, because yesterday when I was watching the news and listening to the chairman of MBA Lagos branch talking about how in Lagos, they have completely complied with recurrent expenditure and they have complied 75% with capital expenditure. Well, just generally, I think it registered even further that part of the things that Justin is asking for is to be able to implement, the judiciary should be able to implement its own projects, such as buying cars for its own judges, building houses if needed, building courtrooms if needed, which will mean inevitably that you'll have to award contracts. And, some people will say, are these the kind of things that the judiciary should be involved in? Isn't that going to take away from the mandate of the judiciary. I'll let you intervene in that, but let me hear the thoughts of.
Well, I mean, to drive it home, the thing is that if such the implementation is done as expected, I mean, the board can be set up. For instance, one of the demand they're making now, they're putting at the table of the Honorable Minister, is that, first of all, the self-accounting law has to be implemented in every state. It's also known as fund management law in state. So that one we set up, we make them to set up boards to oversee whatever contract has been awarded. And don't forget, the third schedule of our Constitution, Part 2 precisely, set up the established commission, Judicial Service Commission in every state. And they can also perform oversight functions over these, the projects or whatever. Because we cannot, because of that, and we should hold on to not implementing the provision of the Constitution, which is the financial autonomy. So I believe so strongly that will be sorted out. It shouldn't be a problem for the Judicial Service Commission to set up a board to oversee any contracts awarded. Yes.
Oh, I'm sure you're aware that wherever there is money, you know, sometimes acrimony naturally, if it's not managed properly, acrimony naturally sets in. But we'll come to Mr. Okutekwa in terms of whether you're satisfied with, you know, that particular explanation that, we are looking for a board, and then we also think that, what board did you call it now? The
Judicial Service Commission, setting up a board to oversee.
The GSC can actually
yes.
look into it. But let's take a break now. When we come back, we'll get Mr. Okutekwa's thoughts on the matter. Please stay with us.
I want to say very clearly that the judiciary is the one holding both the executive and the legislature. And if there's any problem during after election, you run to judiciary. If there's any problem during administration, you run to the judiciary. And our own take is that judiciary must be properly put in its best position. And that is the reason why we are supporting JUSON.
And we've come here to press on the point that this ought to be observed, you know, because the Constitution is sacrosanct and is a document that underpins the very essence of our existence. Therefore, all responsible government at all levels should ensure full compliance with the constitutional provisions. Government should not pick and choose what provision of the Constitution to comply with. So we were Mr. Governor today. The listening governor, he met us at a very short notice, less than 24 hours, because of the sort of regard he has for the bar. So he met with us, and both sides we had a dialogue, and we heard from the other side of the coin. Of course, before we came here, we knew Lagos State had, you know, partly or partially complied with this constitutional provision, and it confirmed the fact that in terms of recurrent expenditure, Lagos State has complied 100%. And in terms of capital expenditure, it's complied 75%. And in Lagos State, no judiciary goes cap in hand to the executive to beg for funds. They all go to the House of Assembly to justify their budget. But all that said, whether there is full compliance or not in Lagos, we've pressed on the point that this is something that ought to be done.
Well, the Deputy President of JUSON, Mr. Emmanuel Abioye, and Mr. Jibrin Okutekwa, SAN, are still with us in the studio. And just before we went on break, you're about to intervene on a matter as to whether or not the GSA will be able to, you know, because you're talking about jumping from frying pan to fire, and he says that, well, the GSA might be able to, you know, oversee and ensure that tenders are properly done within the judiciary.
Well, before I answer you, I just hope that the GSC that Mr. Abioye talks about will not treat the Judicial Workers Union with the disdain for which the Honorable Minister of Labour treated them yesterday. When I watched the Honorable Minister of Labour giving defense as to how people you invited for a meeting at a particular time were kept without words coming to them. I feel like weeping for this country, because in a country where you take issues like this justice delivery system with seriousness that it deserves, those officials ought not to be kept more than 5 minutes waiting without explanation as to whatever the reason was. So for me, speaking for myself, that explanation ought not to come. It's better not to explain than to give that explanation. Having said that, I had...
But they weren't slighted. I mean, he said that we didn't slight anybody. Did you feel slighted?
Well, we first slighted. That's why we stood up. Like I said, I mean, there was no appeal to law. There was nobody coming to tell us.
Did you not feel slighted yourself?
Obviously.
As a Nigerian sitting here, within a reasonable concept, were you feeling satisfied with the explanation? I do not want you to answer, but answer it within yourself.
I was going to tell you that that question remains rhetorical, but
very good. So let's not waste our time. The issue here is, before you see some, I see some of my colleagues praising governors. I do not see how I should praise a man or a woman for what is constitutionally obligated to do. So for me, we must avoid what I call psychopathic praises singing for a person who is under a constitutional obligation to do something. So let's come to this issue. The issue here is, if the money is given, there is a board, whatever name called. You know that under the Constitution, you have the State Judicial Service Commission of each state of the Federation. And in that State Judicial Service Commission, it's supposed to be like the equivalent of the National Judicial Council, where various persons are made up of the members. My fear is not what nomenclature you give to whoever is to oversee and execute a capital project of the judiciary. My fear is how we will not allow the Nigerian factor to creep into the judiciary in terms of implementing this financial autonomy. So I would suggest that rather than having serving judicial officers and people who are in the executive who can do, we should have retired judicial officers of impeccable character and credit, retired lawyers of integrity in Nigeria, to make, whether it is called board, whatever name it is called, to be charged with the responsibility of physical award of contract, development of the court for infrastructure facilities. Because when a judge, or the chief judge, for instance, or the judiciary heads any committee and you award a contract, there is a breach of that contract, where do you head to for a resolution? You are still coming back to the same court. And justice must not only be done, but must be seen to be done. So when there is an appearance that if I go to court, the judges will be biased, then that judice is disqualified from adjudication. So there must be Nigerians who must think loud. There would have been no need for this thinking if all of us are nationalistic, we are patriotic, we respect law and order, we don't prefer our money, because it is a belief generally that the national resources, our natural resources, is a national cake for everybody to share. And it is this ability to share and share it within a particular group of persons and not using it for what it's supposed to be used for, that we are in this state of serious financial developmental quagmire. If we have people who respect law, we have procurement law in this country, where you have to procure and buy things, what you are supposed to do, there is no fear of law in anybody in Nigeria. The reason is very simple. There are no consequences. Look at the murder of George Floyd, for instance. It began in America, it didn't last ad infinitum. But if that matter had begun in Nigeria, you and I will know how many lawyers would have been hired to take issue of preliminary objections, jurisdictional point. We will be chasing shadow rather than say substance. That is why sometimes I don't want to talk. Because when you talk, nobody listens to you. Otherwise, the fine provisions of our constitution does not require this kind of halabalo, going on strike, economy is down, justice is not being served, prisoners are in prison, fundamental rights are being violated. They all, and I can tell you without apology that some people who want this kind of state of affairs are happy that justice is not being served because they are happy when others are not happy. We are in a serious situation. So I will advocate that we need a reorientation of our minds to obey our law, respect our laws. Everyone with respect seems to be lawless. And they now took on the theory that in a lawless society, it's be unlawful to be lawful. So everybody now is in a state of jungle. So our leaders must lead by example. For instance, when meeting was called, the minister ought to be there. Oh, gentlemen, there are things that are not being done rightly, and we couldn't get in touch with you. I apologize. These officers will go home satisfied that they have been respected. But in Nigeria, those who are in power have no respect for the downtrodden masses of this country. That is why they drive against traffic. You and I, your life matters not. And so things are just done haphazardly. And that is why everybody now takes to a profitable venture in this country, crime. Because it is more profitable to go to crime now, and I'm not advocating it, but that is what the leadership seems to be suggesting to Nigerians to do, than to go read book and get educated. Employment, are we not aware how employment is in a state of commercial value?
It is,
so, for me, when I think of this country, my adrenaline is always high. I feel that the resources, we are in the midst of river, but very thirsty. Why? Because our resources are not being applied in the right direction, how it should be applied. And those who are not applying it rightly knows that no consequences will follow. Like Liu Kuan Yew said, if you want to stamp out corruption in Nigeria today, make example from the top.
You know, it is amazing how you have been able to link a whole thread of issues, you know, stemming from just the Jusun strike, saying that it's just a symptom of how we haven't upheld the rule of law. But let me quickly flip this to Lagos now, as I understand my colleague has questions for you. Ayo.
Thank you, Maokwe. I wanted to ask Mr. Okutekpa this one first of all. You heard the MBA in Rivers State say to the governor, who says, of course, he's been compliant. So they were asking him, what happens when you're gone? And they raised the question of not just starting an idea, but of sustaining it. Is there a likelihood that even if after these governors leave office, there could be a situation where the autonomy, financial autonomy to the judiciary could be upturned? Is there any thinking along the line of ensuring that there is no upturning by subsequent administrations?
Well, Ayo, good morning. I think it's a nice question you have asked. The fear of my colleagues in Rivers State was not unfounded. Nigeria seems to operate what I refer to as ad hoc system. We don't have a system that is put in place that is well respected, and there is no institutions to see to enforcement of our laws. So everyone that comes to power comes with his own varieties of idea, depending on what he wants to do and how to do it. And because Nigerians are just followers, so if we have good leaders, Nigeria will follow. If we have bad leaders, Nigeria will follow. So all that we need to do now, the fear that my colleagues in River expressed to my colleague, the Governor Nyesom Wike, was not an unfounded fear. But again, the answer of the governor what he will not be able to guarantee is also an example of how things have gone haywire. Because if there is a policy trust, a policy statement, constitutional provisions, it does not require horsewhip. It does not require Jusun to go on strike. It does not require MBA to go to visiting them, to asking them to do what they needed to do. But we have left governance now to go to appealing to people who appeal to us, to govern us, to do what they are supposed to do. And so you discover therefore that when you link all of this together, sovereignty does not belong to Nigerian people. Sovereignty belongs to the power that be. And that is why they determine what to do, pick from the provisions of the Constitution. So there is no guarantee that Governor Nyesom Wike will be able to tell his predecessor, you must, his successor, you must do financial autonomy. Mark you, most governors are quarreling with their successors in office. So, what if his next person coming there is not from his political party? Or even if he's from his political party, and the person does not even share his ideology of respecting the Constitution. And I do not want to the use of this word, giving financial autonomy.
What I find interesting also is the fact that, you know, we've talked about some of these executive governors, they're not outsiders. Some of them are legal practitioners. They're lawyers.
That's what amazes me too, Maokwe. And I keep wondering on a daily basis whether there is a spirit that changed you from who you are the moment you get into government. Because if you see some of the things, perhaps they are seeing some things that we cannot see with our ordinary eyes. Otherwise, the provisions of Nigerian Constitution, as far as independence of the judiciary is concerned, is as clear, much more clearer than even the white you can see. And for any person who is sufficiently literate, not even learned, to appreciate the purport and content of that law.
Well, Mr. Kutepa, I also recall that you said, pardon me, I also recall that you said this is an impeachable offense, and that's a big deal. But, you know, some will also say, who will then impeach the governor? So who will begin those proceedings? Is this legislature that is also calling and agitating for its own independence to a large extent? But I know Mr. Abioye might want to weigh in on what happens, you know, for successive administrations across states when it comes to this financial autonomy. But add to that also, Mr. Abioye, just to put it on record, there was a section of the media that was reporting that you had maybe suspended your strike and all that. Just to be clear, has that happened?
Not at all. The strike was the prerogative of the National Executive Committee of our union. So the strike is still on as far as we are concerned. So there's no suspension yet until and except the needful is done.
So the report about the suspension, is it of the strike or of the protest, of the march, or was it just misreported?
Well, I think it was mixed reported, but what we suspended was the protest as at Tuesday when we were called for the meeting. So we were expecting that something positive will come up in that meeting. But of course, like you reported earlier, there was no meeting yesterday. So the strike is still on. The strike is still on.
Okay, I don't know if you want to...
we get our demand is being attended to.
Right, I don't know if you want to quickly wade into that discussion about what happens moving forward, because we don't want to see Justin go on strike after 2023 or after governors leave. So what is the thinking regarding that? Do you think there's any issue around that, or you think if it's sorted now, then that flies for the rest of our life as a nation, as it were?
Oh, obviously. You want me to respond now?
Yes, please.
Okay, obviously, I mean, if the solution is brought to bear of the problem of the lack of financial autonomy, that's the end of the strike, definitely. So don't forget, we have sundry issues that we're trying to solve and present before the government, but we see the financial autonomy as the basis for which every other issue can be resolved. So if the financial autonomy is implemented as we have been agitating, definitely, I mean, there's no need for us to go on strike anymore. I mean, so several as the administration, like Lieutenant 6 said, the rule of law, that is the grand norm, the Constitution of the Federal Republic of Nigeria, the Section 1 said that we, the people of Nigeria, having solemnly resolved and firmly resolved too, we are going to abide by this law. If a governor or whoever is in power swore to oath by the Constitution that's going to uphold it, so we believe that such oath ought not to have been made, without any regard to it. I mean, obviously, it's supposed to be our grand norm, and that's what it is. So if any successive administration come on board, the only thing that can guide them is still the Constitution.
Right.
So apart from the fact that, don't forget, we went to court to litigate over this matter, and the judgment is still subsisting up to now. There's no stay of execution. There's no appeal.
Mr. Abure,
appeal the judgment.
If I could quickly come in here, there's another issue I'd like to raise. I mean, yes, while the talk about financial autonomy is ongoing, there's also the talk about corruption in the judiciary. And I'm sure you recall that corruption index, the survey, the pilot survey which ICPC put out, which ranks the judiciary as the top. And it mentioned, court staff, clerks, registrars and all, as being largely involved in this bribe for judgment issues. In fact, put it at 21%. So what is the thinking regarding that? Is this also going to resolve that issue? Because when we talk about justice, it's the whole gamut.
Well, of course, I believe so. Without justifying anybody who's into who's corrupt among the whoever has been indicated to have been corrupt among the staff, maybe the stakeholders in the administration of justice. I believe so strongly, without justifying any action of corruption, if the financial autonomy of the judiciary is implemented, obviously it will go down to everybody. The court administration will be more effective, and of course, it will reflect in what we do. Corruption is everywhere in the society, not only limited to the judiciary. So I want to believe so strongly that part of the corruption that we are trying to fight is that somebody is not implementing the fund that's meant for the public the way the law says they should implement it. I mean, the fund that is not being disbursed according to the rule of law. It's not all the corruption, financial corruption, that somebody is not adhered strictly to the provision of the Constitution to disburse the money that meant for the judiciary. That's part of the corruption, obviously.
All right, let me turn to Mr. Kutekpa on this one. In your piece, you did ask that the bar and the bench come together to fashion out an enduring judicial system. But does financial autonomy actually guarantee judicial independence, given the fact that, the way judges are appointed remains an issue? So will there still be need to talk about judiciary reforms?
Thank you, Chamberlain. I'm happy you referred to the piece I wrote. I said financial independence is just a tip of the iceberg. There are much more issues that require us to come together. And I have advocated that there should be a stakeholders meeting involving the leadership of the bar, the leadership of the bench, the top echelons of the profession, like the body of benchers, the body of senior advocate of Nigeria, leadership of judicial. Then let us come together and ask ourselves, why is it that what we are not expected to do, we are deeply involved in doing it? Mark you, the profession that I belong to is a profession of light, where we have our code of ethics, we have our code of conduct. There are code of conduct for judicial officers. There are code of conduct for legal practitioners. If a lawyer, what is sought, for instance, respects Rule 1 of the Rules of Professional Conduct and does not engage in frivolity, ensures that the rule of law is obeyed, is honored, he will not file a frivolous processes to delay justice. A judicial officer, for instance, who is what is onion, will not solicit or appears to solicit even a favor from anyone. And so I will advocate that apart from financial autonomy, there must be an independent recruitment process. Recruit the best of the best. I have said that from the beginning of this program. The situation where what you know does not matter, but who you know does not augur well for the judiciary. And the judiciary is the one that has been licensed to decree that somebody should be killed, not even President Muhammad Buhari. So, if that is the case, then the person to man the bench to make that pronouncement must be somebody of strength, of character, somebody of great comportment, somebody who cannot be intimidated into giving justice, somebody who does not go to discuss the case outside of the facts presented by party before him, somebody who does not go to the market to solicit for help from litigants from him, so before him. So that's my suggestion to us. And we have a lot of us, a lot of lawyers, a lot of judges that are of credit and of repute, but are they allowed to operate without interference, either from within or from without? That's the big question. So the independence of the judiciary is completely a necessary ingredient for the rule of law. Once judiciary is not independent, once you have lily-livered judges, once what you get in court are judgment devoid of justice, then you are giving room for anarchy. And once there is anarchy, the economy will be in jeopardy. There will be no place for industry. Then life becomes shortish, brutish, and nasty. And then every one of us will run helter-skelter. And your guess is as good as mine. So it's in the overall interest of every one of us that judiciary be independent.
Indeed, well, little drops of water make the mighty ocean. If you say that, financial autonomy is one step, let us see just how much progress Jusun will make with that. But we have to thank you, gentlemen, for coming on Sunrise Daily this morning. Mr. Emmanuel Abioye is Deputy President of Judiciary Staff Union. Thank you for coming.
Thank you very much.
And Mr. Jibrin Okutekpa, who's been on fire this morning. You say when it comes to issues of Nigeria, your adrenaline is always pumping.
Yes, because we're unfortunately in this kind of dire situation. And there seems to be no hope for generation tomorrow unless we all cry out. That's why I agreed to be here this morning.
Thank you for sharing your honest thoughts. He's a senior advocate of Nigeria. Well, that's it for this segment. We will be taking on another issue, and hopefully the adrenaline will remain on the same level when we come back from this break. Please stay with us.